Hello, my name is Paul Hutchinson and I'm the founder and director of a law firm based here in the southwest of England. My practicing career stretches over 20 years. I was a private practice solicitor with a firm in Bristol before being made redundant around about 18 years ago, which is when I founded the firm that I run now. And my role in life is to provide advice to clients on the subject of asset protection and tax planning, to try and protect as many of those assets that we've worked all our lives to get from all the nasty third-party attacks, and also to reduce the amount of tax that we pay not only during our lifetimes but when we pass away. I'm STEP qualified, having sat and passed the Advanced Certificate in Will Preparation, and I was also published in the 2017 Legal Parliamentary Review. Now, I'm not always just based here in the Southwest. I work with a strategic network of very, very trusted partners who can provide these services all throughout the United Kingdom. So wherever you are based, we can help you with asset protection and tax planning. So just what do I mean by estate planning? Now, you may have consulted your lawyer, wondering what estate planning is all about because it's a buzzword, it's something that is often spoke about today. What I like to describe as estate planning, we can divide into two main sections. We can look at asset protection and we can look at tax planning. Now, within those two subheadings, what we can look at again is a further division between lifetime and death planning. So something that we've all probably heard of are wills. Wills are documents that we look at putting in place to set out where we want our assets to go when we pass away. But we haven't always heard of things like lasting powers of attorney. Now, lasting powers of attorney are documents that we put in place to make sure that when we lose capacity, we lose that ability to make decisions for ourselves, that the people that we choose make those decisions on our behalf, rather than leaving it to the court of protection for someone that you don't know to come in and start making those decisions on your behalf. We can then think about trusts. What are trusts? I shall go into those in a bit more depth a little later on. But trusts have been around for about 3,000 years. These are not a new product. Okay? Trusts will provide asset protection and in some cases tax planning opportunities to protect those assets such as your main home, your rental property, your investments, your cash, your savings. So estate planning can provide an opportunity for all of us to put documents in place and planning in place to maximise what we can pass on to the next generation free of tax or paying as little tax as possible and in as protected an environment as possible. So let's have a little think about wills. How many of you have heard of wills? How many of you have browsed wills, whether it's on the shelves at WH Smith or you've actually been to your lawyer to discuss the importance and benefit of putting a will in place? Now, one of the most underrated benefits of having a will is guardianship for your children. Just think about it. If you pass away and you've got any children under the age of 18, what would happen to them? Most people think that if there are grandparents alive or you've got brothers and sisters alive or even older children, that your minor children will be cared for by those individuals. But that's simply not the case. In most situations, if you have minor children, then there will be a court hearing to decide who is best placed to care for them. And whilst that court hearing is taking place, your child will be in care. Now, there's a huge debate about whether the foster care system and the social care system is adequate and fit for purpose. But what I can assure you is that if you know who you would like to look after your children when you pass away, you would much prefer to make that decision than leave it in the hands of the courts. And it's a will with a statement of guardianship where you can put those wishes into operation. So for people that say, gosh, I don't need a will because I've only got a few £1,000s in the bank and I rent my property, especially true with younger couples, they've got a toddler. Putting that guardianship clause in a will is extremely important. And if you do a will for no other reason, that's something that you should really give serious consideration to. The other myth is that when you have a married couple, for example, they say, it's okay, everything will just go to my wife. If I pass away, there's nothing to worry about. I don't need a will. Well, again, that's simply not true. Depending on the value of your estate, there is what we call the statutory legacy, a fixed sum of money that will pass to your spouse when you pass away. And if you have children, then that statutory legacy will be reduced and some of your estate will go to your children rather than to your spouse. Now just think what confusion that may cause if they're your children and not your spouse's children. So having a will in place will ensure that the people that you want to look after your estate when you've passed away, commonly known as your executors, and to care for your children, what we call guardians, is actually what is going to happen, rather than leaving it to what we call the intestacy lottery. Some people say, well, surely I can just put a £10 DIY will kit from my local retailer. Now, there is an argument to say that having that is better than nothing at all. But having that professional advice on the structure and the tax efficiency of your wills and whether the people you want to appoint are the right people is something that you should give serious consideration to, rather than just filling in the blanks on a generic sheet of paper. So what is an LPA, a lasting power of attorney? Now, an LPA is something relatively new in estate planning. LPAs have only been around since 2007. Prior to that, they were called EPAs, or enduring powers of attorney. Now, whilst wills deal with what happened when we pass away, a lasting power of attorney is a document where you can appoint the personal persons of your choice to make decisions about your property and your financial affairs and your health and welfare when you no longer have the mental capacity to do so. Now, just some common examples of this could be that you've had a stroke, that you've had a fall at work, you've banged your head, you've had a car accident, you're in a coma. Even obviously with the recent COVID pandemic, people were in hospital in comas, unable to make those decisions. Now, if you don't have a lasting power of attorney in place, appointing your spouse, your children, your brother, your friend to make those decisions on your behalf, someone that you care about, a loved one, will have to apply to the Court of Protection for a deputyship order. Now, the problem with the Court of Protection is that the application fees are incredibly expensive. At the moment, they're just shy of £400 for an application for a deputyship order. The other issue is the time. Unless the application is urgent, basic applications could take between 6 and 9 months to be heard by the court. And even then, your application may not be granted. Add to that the additional legal fees involved with the huge ream of forms that you need to fill in for a deputyship application. It is far, far less cost effective than having a lasting power of attorney document in place. Now, one of the most common mistakes with lasting powers of attorney is a hangover from the old enduring power of attorney system, and that is that they're just left on the side in their unregistered format. Now, at the moment, registration takes between 3 to 4 months. At the height of the COVID pandemic, this was 6 to 7 months. Now, during that time, your attorneys cannot make those decisions on your behalf. Now, with the old system, you couldn't register your power of attorney until you'd lost capacity. But with the new lasting powers of attorney, they can be registered, put in the drawer, and brought out at a moment's notice when the unforeseen happens. So as well as looking after your wishes when you pass away, please make sure that you've got your documentation in place for when you're alive, but you no longer have the capacity to make those decisions yourself. But if inheritance tax planning with trusts is something that you're interested in, then we do have the Settler Excluded Asset Protection Trust. This is a trust not for the family home, but for other assets, which if you put them into trust more than 7 years before you pass away, the value of those assets will be outside of your estate for inheritance tax purposes. And this can all be done without triggering charges to capital gains tax, thanks to various exemptions and reliefs. And if this is something you are interested in, please do ask, and we'd be more than happy to talk to you about it. So we have what I term the triangle of estate planning. We have wills, we have lasting powers of attorney, and we have lifetime family asset protection trusts. Wills appoint the persons that you choose to look after both your children and your assets to ensure that they pass to your chosen beneficiaries as quickly and as smoothly as possible when you pass away. We have lasting powers of attorney, which are documents that appoint the people that you choose to make decisions about your property and financial affairs and your health and your welfare when you're no longer mentally able to do so. And then we have lifetime family asset protection trusts, which protect your assets against third-party attack from divorce, from bankruptcy, from foreign taxes, and potentially from future care fees. Now, I wish I was able to cover the whole of the United Kingdom, but unfortunately, I'm not. So I work with a network of trusted associates, strategic partners, who will be able to provide you with bespoke advice about some, all, or other aspects of estate planning that we haven't necessarily covered today. So give them a ring. Find out what they can do to help you. Now, you may choose to put all of these things in place or none of them, but at least have the conversation to understand the consequences of the decisions that you're making. You can go in fully informed to make sure that your family's future is as protected as it can be.